All right, well, greetings to all and welcome to the first lecture of the Road to COP26 CMA3 Preparatory Lecture Series. I am Nilüfer Oral, Director of the Center for International Law at the National University of Singapore and one of the co-organizers of these lecture series. It is my great pleasure to introduce you to my two co-organizers, Professor Petra Minarop from the Durham University Law School. She has worked and published extensively on climate change and was appointed by the Pro-Vice Chancellor for Global Affairs as the academic lead for COP26 for Durham University. Professor Christina Voigt from the University of Oslo Law School and chair of the IUCN World Commission on Environmental Law Climate Change Specialist Group. She is also co-chair of the Implementation and Compliance Committee under the Paris Agreement. She has extensive experience as a legal advisor and climate negotiator for Norway. We decided to organize this series of lectures in preparation for COP26 that will take place in Glasgow, Scotland in November this year. The focus of these lectures are specifically on the key issues that will be part of the agenda at COP26 and MPA3. We are delighted to have very well-known experts with tremendous knowledge and insight to guide us into what will be an important meeting of states and many members of civil society. Today, we are extremely fortunate to have as our first lecturer a name that is well-known to many, Professor Dan Bodansky. He is a Regents professor at the Sandra Day O'Connor College of Law at the Arizona State University, and he is a preeminent authority on global climate change. Now, my dear colleagues, Petra and Christina will also provide some opening comments. I hope you will continue to join us over the coming months for our On the Road to COP26 lecture series. Petra?
Oh, thank you so much, Professor Oral, for this very kind introduction. I would like to thank Professor Oral and Professor Vogt for working on this series together to make this happen in a very short period of time. I think we've given this lecture series a sense of urgency, and a sense of urgency is needed for addressing climate change in the light of the scientific evidence. Now, the UK government has identified 5 themes where ambition should be increased to meet the Paris Agreement's temperature target. These themes are adaptation and resilience, nature, energy transition, clean road transport, and finance. Accelerated action is certainly necessary for all of these topics, but COP26 and CMA3 are also about international law, and accelerated action is needed at the level of international decision-making and lawmaking, and this is what we should expect from COP26 and CMA3, and this is also how we can measure the success of this Conference of Parties. Now, this lecture series is part of the wider mandate that arises under Article 12 of the Paris Agreement that encourages cooperation and education. It states that parties shall cooperate in taking measures to enhance climate change education, training, and public awareness. And enhanced action will flow from that. Information and knowledge are therefore key pillars for positive change and for climate protection. Now, thank you very much to Professor Bodansky for presenting today and for sharing your expertise and knowledge in the first lecture of this monthly lecture series. It is a great honor to have you with us, and I'm very much looking forward to listening to your lecture. Thank you also to the audience. We've got a great number of people attending this call. Now, this lecture will be recorded and made available online afterwards, including on YouTube. I would also like to thank everyone who is working hard behind the scenes to make this happen, and especially Stan Neil. And if there are any technical issues, he's asked me to inform everyone, please send him an email or use the chat function for that. Regarding some further housekeeping, please could you post your questions for the discussion after the lecture in the Q&A section, and I will then read the questions out. So with that, I hand over to Professor Vogt for her opening remarks. Thank you.
Thank you very much, both to Petra and to Nilüfer, and a very warm welcome to all the many participants who join us here today. On behalf of the International Union for the Conservation of Nature, IUCN, World Commission on Environmental Law, I'm very proud and very delighted to collaborate with the Center for International Law at the Singapore National University and the Durham University on this important lecture series, which will become a part of us and our work all the way to November, when we hopefully will have COP26 and CMA3 in Glasgow. And I'm very, very delighted, of course, to also welcome my dear friend and colleague, Dan Bodansky from sunny Arizona, joining us here in the early spring days in Europe. I'd just like to say a couple of words why Glasgow is so important, and Petra already alluded to them. There are three main points of why Glasgow is really a critical juncture in international climate governance. First of all, it is important to finalize the outstanding elements of the Paris Agreement Rulebook. As you perhaps know, there are a couple of elements that are still missing, and they are very important for the effective functioning of the Paris Agreement. One of them is, of course, the rules around Article 6 and carbon markets, and we'll talk about this later in the lecture series. Another element is around common timeframes for nationally determined contributions. That's something that is still not quite decided. And yet another element are general guidelines around the biennial transparency report and a technical expert review. These are crucial elements of the Paris Agreement, and there are still outstanding issues which hopefully Glasgow will deliver. A second reason why Glasgow is important is, of course, it gives state parties the opportunity to follow up on the request to enhance their NDCs or put forward a new NDC, depending on the timeline they had in their initial NDC. And as you perhaps know, several parties have put forward updated and enhanced nationally determined contributions, but we hope, of course, to see until November that there are many more parties who follow that call. And it is important to increase ambition in order to stand a chance to adhere to the Paris Agreement temperature goals. And the third aspect why Glasgow is important, because it will show to the world that when we can move collectively forward, even under the constraints of a pandemic, which has now been with us for more than a year, but we will show progress nevertheless. And on this road to Glasgow and beyond, law has become a very important, maybe the most important, the most crucial lever to bring about the changes needed in order to comply with the Paris Agreement's goals. And here I only briefly want to mention 5 reasons why we see law becoming so important. First of all, law in terms of legislation is the tool to translate the objectives that parties put in their nationally determined contribution, which is not under international law legally binding, into legally binding national commitments. We see many states adopting climate acts, climate laws, or other climate regulations, and that makes that international commitment legally binding in domestic legal systems, and thereby also judicially reviewable by national courts. And the second aspect why law is becoming more important as we speak is, of course, that international rise in climate litigation that we see really as a worldwide phenomenon, where citizens, youth organizations, children, NGOs are taking governments and companies to court with the aim to enhance climate ambition. A third aspect where law is becoming more and more important is in the regulation of financial institutions, of economic play, of private companies through all sorts of regulations, including free trade agreements and investment law, to capture the potential and the possibilities that economic regulations provide us in order to enhance climate action. And finally, we also see a cross-fertilization of different areas of law in order to provide joint solution to the climate challenge. For example, biodiversity and climate change, or law of the sea and climate change, human rights and climate change. It's such a global challenge. It brings different areas of law together, hopefully in providing a joint solution. And with that, I just want to give the floor to Dan, and we're all very much looking forward to your talk, Dan.
Well, thank you very much. It's a pleasure to be here, and it's an honor to kick off this lecture series. So I want to thank Nilofer and Petra and Christina for inviting me. It's great to see them again. And I also want to thank Stan Neal for taking care of all the technical details relating to this lecture series. Since mine is the kickoff lecture, and you're going to be hearing from experts on various issues in much more detail, my goal is to really give you a very broad overview, sort of the view from 30,000 feet or 10,000 meters. What I'm going to do today is first, I'll give a little brief history of the climate change regime, how we've gotten to where we are, then review what I call the Paris paradigm, the Paris Agreement, then talk a little bit about the evolution of COPs since the beginning of the climate change regime almost 3 decades ago, and then focus on Glasgow and what we can expect from Glasgow. So if we're looking back on the road to Glasgow, I like to describe the evolution of the climate change regime as a play in 4 acts. The first act was the Framework Convention, second act centered around the Kyoto Protocol, the third act focused on the Copenhagen Accord and Cancun agreements, and then the fourth act, of course, is the Paris Agreement, and that's the act that's still ongoing. And in this evolution, in this 30-year history, I think it's important to identify 3 recurring themes that run throughout this evolution. One is the question as to how much the international climate change regime should be top-down and how much it should be bottom-up. In other words, how prescriptive should it be in telling countries what they need to do versus how much should it be focused on what countries nationally determine they should do, and then the regime is trying to facilitate and coordinate that action. The second dimension has to do with the legal bindingness of the regime. How legally binding will it be or not? And then the third has to do with differentiation. And I think there's a back and forth to some degree in the evolution of the regime from the Framework Convention initially, which is largely bottom up. It's a treaty, but not everything's binding. It's got very strong differentiation. Kyoto Protocol, very legally oriented. Copenhagen going to the other extreme, and now we have the Paris Agreement. So I want to just briefly walk through this history. So it starts, of course, with the UN Framework Convention on Climate Change, which essentially acts like a constitution for the climate change regime. It establishes the basic system of governance, including the ultimate objective of the regime, its principles, general obligations, some basic institutional arrangements, most importantly, the annual conference of the parties, differentiation based on annexes, Annex 1, non-Annex 1 countries. And the convention was, of course, open for signature at Rio, entered into force, and now has universal participation. The next act of the climate change regime focused on the Kyoto Protocol. The idea of the Kyoto Protocol was to develop much more specific obligations on countries to reduce emissions, but only focused on Annex 1 countries, so-called developed countries. So key features of Kyoto: a top-down regulatory approach involving internationally negotiated and agreed limits on greenhouse gas emissions. It's essentially a one-size-fits-all approach because it was the form of the obligation was the same for all of the Annex 1 countries, absolute economy-wide quantitative emissions target. Those targets were legally binding. There were very detailed rules elaborated after Kyoto for how this target-based approach would work, including rigorous accounting and compliance mechanisms, and then extremely strong differentiation. Targets were applicable only to Annex 1 countries, and from the very start of the negotiations in Berlin, at the Berlin Mandate, a view that there would be no new commitments in Kyoto for developing countries. The third act was centered around the Copenhagen Accord and then the formalization of the elements of the Copenhagen Accord in the Cancun agreements the year after that in 2010. There were huge expectations for Copenhagen, so I think many in Copenhagen were disappointed given the high expectations for Copenhagen, and particularly disappointed that Copenhagen was a political instrument, not a legally binding instrument. Many people wanted Copenhagen to agree to a legally binding instrument to supplement or replace the Kyoto Protocol, but the Copenhagen Accord was adopted by 28 heads of state as a political instrument. But I think Copenhagen, despite that disappointment, was substantively very significant. It did a number of very important things. It established the temperature goal of 2 degrees centigrade included in the Copenhagen Accord. It expanded the regime in terms of its coverage. So for the first time, there were emission pledges from many developing countries, including China, emission pledges from more than 80 countries, and thereby expanded the amount of global emissions that were now being covered. Quite small percentage under the Kyoto Protocol, a large majority of emissions under the Copenhagen Accord. It also established a transparency regime that was applicable not only to developed countries, but also to non-Annex I countries. And then financial pledges by developed countries to mobilize 100 billion per year by 2020. So essentially, developed countries pledging finance 100 billion a year by 2020, developing countries making emission pledges and signing on to a transparency regime that included elements and processes relating to them. So the question going into the Paris negotiations was which of these two approaches the Paris Agreement would reflect. The Kyoto Protocol approach, which is highly prescriptive, highly legal, highly differentiated, or the Copenhagen approach, which was not so prescriptive, bottom-up architecture, countries getting to make national pledges as to what they were going to do, relatively few international rules, political rather than a legal instrument, and a more limited differentiation. And I think it's probably fairly well agreed that Paris Agreement tried to solve this choice between the Copenhagen paradigm or the Kyoto paradigm by taking a hybrid approach, what some call a Goldilocks solution. So elements of that, the nationally determined contributions, so bottom up in terms of nationally determined contributions, but with international rules to promote transparency and accountability. It's a treaty, but not all of the provisions are legally binding. And it has very nuanced differentiation. It abandons the very fixed, rigid structure of the annexes in the UN Framework Convention and Kyoto Protocol, involves self-differentiation and mitigation commitments, and financial commitments are what remain bifurcated between developed and developing countries. So let me walk through in a little more detail now the Paris paradigm, because that is, I think, the current paradigm in the climate change regime. So I want to just elaborate a little bit more detail some of the key elements of the Paris paradigm. So I think it includes really 4 key elements. The nationally determined contributions that countries put forward, transparency to promote ambition and accountability, the ambition cycle to promote stronger action over time, and a nuanced approach to differentiation. So let me briefly discuss each of these 4 elements of the Paris paradigm in a little bit more detail. So the first element is the nationally determined contributions. That's really the centerpiece of the Paris approach. And so these are bottom up. Each country can nationally determine the type of contribution it wants to make, the scope of its contribution, the coverage in terms of greenhouse gases of its mitigation contribution. So it's very bottom up in terms of the substantive content of nationally determined contributions. But then there are procedural obligations to maintain an NDC, to take domestic measures, to communicate successive NDCs every 5 years. So there's procedural obligations that I'm going to elaborate a little bit more in my next slide. But in terms of substance, countries get to determine the substance of their contribution. The Paris Agreement has only soft expectations relating to substance. Developed countries should take the lead by having economy-wide targets, while developing countries only are encouraged to move in that direction. There's the ideas of progression and highest possible ambition. So there are substantive principles involved in the Paris Agreement, but they're more like soft expectations than legal requirements. And then importantly, the nationally determined contributions are not legally binding. There's no legal obligation to achieve NDCs, and was one of the main issues in Paris as to what the legal status of NDCs would be. So the second element of the Paris paradigm starts with a bottom-up, non-legally binding approach to nationally determined contribution, but then it pairs that with extensive provisions relating to transparency. And transparency, I think, is largely what the Paris paradigm uses to try to promote ambition and accountability. So there are legally binding procedural obligations in Paris to provide information when you're submitting your NDC, so it's clear what your NDC actually says, what you're actually pledging to do. So this is what's referred to as ICTU, or information necessary for clarity, transparency, and understanding. You have to be accounting for your NDCs, and you, as parties, have to report biennially on their emissions and on their progress in implementing and achieving their NDCs. And for developed countries, they also have to report on their support provided. And then finally, in part of the transparency system of the Paris Agreement, there are various international review mechanisms. There's technical expert review. There's peer review by other countries that facilitate a multilateral consideration of progress, to use the terminology in the Paris Agreement. And then there's the implementation and compliance mechanism, which Christine is in a much better position to discuss with you than I am, since she's one of the co-chairs of that mechanism, that committee. So the third element of the Paris paradigm is the ambition cycle. So it was recognized in Paris that the NDCs that countries had put forward in Paris were not putting the world on a pathway to achieve the temperature goals of the Paris Agreement, the 2-degree temperature goal, much less the 1.5 degree more aspirational goal. So the Paris Agreement includes the so-called ambition cycle, which is a 5-year cycle intended to have countries ratchet up their contributions over time to raise the ambition of their contribution. So in these 5-year cycle, countries first implement their NDCs, they account and track progress, they report on what they're doing. This goes through various review processes, but then it goes through what's called the global stocktake, which takes stock of what countries are doing, what countries have reported on, and assesses the progress overall of the parties to the agreement in achieving the goals of the Paris Agreement. And then that global stocktake becomes the basis for the next round of NDCs. And so on this 5-year cycle, countries are supposed to be coming forward with NDCs, which become progressively more ambitious, progressively stronger, and that will then close the gap between what countries are doing right now and what they need to do if the world is going to stay well below 2 degrees and hopefully reach the 1.5 degree temperature goal. The fourth element of the Paris paradigm has to do with differentiation. By Paris, I think no one was really arguing to use the 1992 annexes in the Framework Convention. There was widespread agreement going into Paris on the concept of nationally determined emissions targets. But the key issues were whether in the nationally determined contributions there'd be any distinction recognized between developed and developing countries, whether on finance the donor pool would be broadened beyond just developed countries, and on transparency and accountability, whether the system should move beyond the existing, what was then the existing approach, which had different transparency provisions dealing with developed and developing countries. And so the outcome of Paris really, I think, takes a quite nuanced approach to differentiation, a different approach to differentiation with respect to mitigation, finance, and transparency. So each of them has their own approach to differentiation. With respect to mitigation, there's not differentiation in the procedural commitments specified relating to mitigation, the obligations to provide information up front, the obligations to report. These are procedural commitments that apply generally. There's self-differentiation of NDCs. Each country gets to determine what its mitigation contribution will be, so they get to self-differentiation based on what they think is fair. And then there's some soft distinctions between developed and developing countries in terms of normative expectations. The expectation for developed countries of having quantitative economy-wide targets, and only the encouragement for developing countries to move in that direction, for example. Finance is the area where there still is bifurcation between developed and developing countries, but it's, I think, less stark than it had been previously. Developed countries continue to be required under an obligation to provide finance to developing countries, but the donor pool has expanded. Other countries are also encouraged to provide support. And then on transparency, there are common modalities, procedures, and guidelines, so that's not so differentiated, but then a recognition that there should be flexibility for developing countries but it's only those developing countries that need it in light of their capacity. So instead of having a strong differentiation, it's more a flexible approach that's reflected in the transparency provisions. So just a few other features of Paris that are important to mention. So there are, of course, the temperature goals, the goal of holding temperature increase well below 2 degrees centigrade and to pursue efforts to limit the increase to 1.5 degrees. There are the emission goals relating to peaking and net zero emissions in the second half of the century. There are goals relating to climate adaptation and resilience. And importantly, also a goal about making financial flows consistent with the other goals. And these include not only public financial flows, but also private financial flows. There are the two market-based approaches in Article 6, which Christina mentioned, which I'll come back to. There are measures to encourage greater adaptation efforts. The Warsaw International Mechanism dealing with loss and damage was incorporated into Paris, but the decision adopting the Paris Agreement said that wouldn't be a basis for liability or compensation. And then there's the finance mobilization goal, the $100 billion per year of finance, both public and private finance. And that goal originally applied only to 2020 in the Copenhagen Accord, but now it's been extended through 2025. Okay, and after Paris was adopted, as with many agreements, Paris provides the basic structure, but then a lot of the details need to be filled in. So there was another 3 years of negotiation after the Paris Agreement was adopted to try to work out the Paris Rulebook. And I think there were really two main tasks in the Paris Rulebook negotiation. First, to elaborate the parties' obligations, to provide more detail about what information, for example, parties needed to submit. And the second was to operationalize the various international mechanisms in the Paris Agreement. The Article 6.4 mechanism which is similar to the Clean Development Mechanism in Kyoto, project-based approach to market mechanisms, technical expert review, the global stocktake, the implementation and compliance mechanism. All of these needed to be operationalized through rules. And I think there was a lot of question in the post-Paris period whether the Kyoto Rulebook negotiations would really essentially reopen the Paris paradigm, because Paris has a lot of constructive ambiguity. There's a lot of wiggle room. And so the question was, I think, at least for me, was to what extent would the Paris Rulebook be faithful to the Paris paradigm? Would it respect national determination? Would it focus on procedural obligations and transparency? And would it maintain the more nuanced approach to bifurcation in Annex 1 and non-Annex 1? So my cartoon on the left is basically everybody has totally different thoughts, can't stand what they agree, but they will, of course, all say yes. And so the question was, is that what happened in Paris? Did everybody basically still disagree, but said yes, but then, just to live on to fight another day in the Paris Rulebook negotiations and reopen everything? So the Paris Rulebook was adopted in Katowice. It's quite detailed. And I think, to my mind at least, it does stay faithful to the Paris Rulebook. There's still a much more detailed elaboration of the transparency requirements. Those are mostly mandatory in nature. There's also consideration and some elaboration of the other provisions. And it's all very carefully calibrated in terms of its legal bindingness. I won't go through this, but would be happy to come back to this in Q&A if people are interested. But some of the provisions in Paris are shall, some are recommended, some have self-differentiation, some are self-determined with transparency. So there's a very calibrated approach, just as there was in Paris, to the issues of both legal bindingness, how legally binding or not things would be, and how differentiated it would be. And I think that carries through in the Paris Rulebook, and you see the similar kind of very calibrated approach to legal bindingness and differentiation in the Rulebook. And this is particularly clear in the transparency framework, where there's the idea of flexibility for those developing countries that need it. So there's an approach in the Paris Rulebook where the question is to which countries need flexibility based on lack of capacity. That's left to countries to nationally determine. It can't be second guessed. So countries get to determine for themselves whether they need flexibility. But then the Paris Rulebook has quite very specified limits on the flexibility. So the flexibility is only for developing countries that need it. It only applies to specified provisions of the transparency arrangements. The types of flexibility are internationally defined and circumscribed. And developing countries that claim flexibility, and they're able to do so on a nationally determined basis, They have to identify the specific provision, the specific rationale and capacity constraints that mean that they need flexibility, and they need to provide an estimated timeframe for improvement. So this is, I think, quite similar in spirit to the Paris Agreement approach, where there is flexibility, there is some recognition of the need for countries to have different, to not be subject to exactly the same kinds of rules, but it's quite calibrated and nuanced in the way it's operationalized. Okay, so what's left in the Paris Rulebook negotiations? As Christina mentioned, the Article 6 rules, these are the cooperative approaches, the two market-based approaches in Article 6.2 and 6.4. Some specification, further specification of the reporting requirements under Article 13, the biennial transparency reports, and in particular, the common reporting tables for inventories, the common tabular formats for reporting progress. As Christine mentioned, I don't have that on my slide, also the common timeframe issue for NDCs. So there's some loose ends still, and important loose ends, particularly relating to, I think, Article 13 and Article 6, the rules for those. So that's sort of what's left in the Paris negotiations track. So let me just turn from that to a few reflections on the evolution of COPs, because I've been going to COPs since COP1. I'm what's called a frequent COPper. I've been to all but 2 of the COPs. And actually, I started following the climate negotiations before there were COPs, when the Framework Convention was being negotiated. So I've been to those negotiations, and then there was a series of meetings after the Framework Convention was adopted, before it came into force, before there was a COP. So there were the now pre-COPs, or before each COP, but these were the pre-COPs before there was even any COP back in 1993 and 1994. So I wanted to just reflect a little bit on the evolution of COPs to set the stage for Glasgow. So COPs, I think, from the beginning have always had 2 aspects. They're meeting of the parties. So they're a convention-based, treaty-based meeting where the parties take care of the business at hand under the treaty, either negotiating additional elements, implementing the existing provisions of an agreement. So it's a meeting of the parties, but then it's also sort of a climate event. It's a focal point. It's a yearly focal point, and I think includes elements like being a trade fair for business to show off their wares, what they're doing, countries as well to show off what they're doing. It's one of the, in some sense, biggest academic conferences of the year relating to climate, because so many people are there and they're presenting papers at side events on all sorts of new research they're engaged in. So it's a gathering, it's a climate gathering, as well as being a meeting of the parties. Now, I think this has been true to some degree in the past, but I think there's been an evolution in the COPs from the early days to now. So in the early days, when I was a negotiator still, which is now 20 years ago, so it's the last time I was a negotiator, we used to refer to things as being mini COPs and mega COPs. And the mini COPs, a lot of COPs were pretty small bore. They weren't attended by that many people. They were didn't get so much attention. And then there were the mega COPs like the Kyoto COP, The Hague, where the Kyoto Rulebook was supposed to be adopted. But then COPs like COP2 in Geneva, COP5 in Bonn, nobody really remembers even, maybe Geneva for a few elements. I'd say Bonn, COP5, COP5. I doubt anybody really has any idea anything that happened at COP5. So there were mini COPs and mega COPs. But now, essentially, every COP is a mega COP. Every COP is a mega COP. There are no mini COPs. Every COP is a huge occasion. So it's transformed in that way. It's, I think, moved from being state-centric to multi-actor. So when I started going to COPs, even a lot of the NGOs who were there, they were mostly focused on the negotiations. I would say if you polled people back in 1993, 4, et cetera, most of the people there were actually paying attention to what was going on in the negotiations. Whereas my guess now is if you did a poll, very few, many people, probably the large majority of people, wouldn't be paying much attention to the negotiations. They're going there for other reasons. So it's become, I think, less state-centric and much more multi-actor in its character. And I think this is, I was at a meeting when there were still meetings right before COVID where this was among negotiators saying, maybe we should relabel and call the side events the main event and the negotiations the side event, because actually the action is more in the side events than it is in the state-centric negotiation part of the COP. And then finally, I think it's moved from being climate-centric to increasingly a theory of everything. So instead of seeing climate as some sort of defined sector to address, we need to address everything: finance, investment, trade, intellectual property, and so forth. And I think this is reflected in a comment by Mark Carney, who's been designated the finance person by the British Prime Minister. Mark Carney is the governor of the Bank of England, who in a talk about COP20 and is in charge of the finance side of COP26, said the objective for private finance work for COP26 is simple: to ensure that every financial decision takes climate change into account. So every financial, it's not just about the $100 billion mobilization, state finance, it's every single financial decision by every actor should be taking climate change into account. So it's becoming, I think, increasingly a theory of everything. So just a few slides to illustrate some of these. So this is showing the participation in COP since the beginning. And you can see in the early days, a lot of the COPs are pretty small. There were a few big ones like Kyoto and in COP3, which had almost 10,000 participants. But now the COPs are all quite big. And if you carry it forward, this is even more accentuated. If you look at Fiji, COP23, which really in the old days would have been a mini COP, now it still has 22,000 participants, twice as large as Kyoto. Madrid, which had changed venues, and so you would expect a lot of people maybe not to be able to go because it was originally going to be held in Lima, and at the last minute it was relocated to Madrid. Still got more than 22,000 people there. So, we've really moved from COPs being about the meeting of the parties, about the business of the convention and various agreements under the convention, to being a much, much larger climate event. And you can also see the range of people coming now. Originally is much, much larger. Originally, there were just bingos, that's the business NGOs and NGOs. Now we've added all of these other constituency, farmers, indigenous peoples organizations, local government municipal authorities, or research NGOs. So many, many universities now are Ringos and attend the conference. Trade unions or Tungos, women and gender, youth NGOs. So just a tremendous number of constituencies. It started with 2, and now we're up to somewhere approaching 10. So if you also look at the layout of COPs, I think there's something to be said for maybe evolution in the layouts of COPs reflecting some of these changes. So this is, by the way, courtesy of Bryce Reddick, who showed me these slides and gave me permission to incorporate them into my talk today. So this is the Paris layout, and Hall 6 was where the negotiations were going on. That's really the focal point. And then these other halls were where various other activities were taking place. Bonn, because it was being held in Bonn and there's not a huge conference facility, they segmented into the Bula zone, which is the government negotiation zone, and the Bonn zone, which is the non-governmental aspect. And really, and I think most people would agree, including government negotiators, that all of the action really was in the Bonn zone. You go to the Bula zone where the governments were negotiating the Paris Rulebook negotiations, and it was just pretty dead. There weren't a whole lot of people there. There was no energy whatsoever. And you went over to the Bonn zone, which was just humming along, and tons of activity. And so forth. And I think that's reflecting sort of the changing priorities and importance of COPs. And then in the Madrid COP, you had to get back to Hall 10, back here at the very far back from the entrance before you got to the government negotiators. All of the stuff you encountered first was non-governmental, non-state actor kinds of things. So increasingly, so I'm not sure that's going to be true in Glasgow. I haven't seen what the layout's going to be and where they're going to put the different things. But I think certainly the Madrid conference suggests that the main events maybe were the non-state actor stuff, and the government negotiations were put back in a corner that probably a lot of people never even made it to in the course of the 2 weeks of the conference. Okay, so let me turn to Glasgow a little bit, and I think implications for Glasgow of what I've just been saying. So what I call sort of the old think and new think on this, maybe just reflecting my own biases. So how do we judge success? And a few people have already talked about this, and who are the key actors and whom will success depend? And I think, I guess I would disagree a little bit with what Petra and Christina said, that how we judge success should be judged by the outcomes on the agenda items. There's the official agenda, so that's finishing up the negotiations in Article 6, finishing the negotiations on common tabular formats and common reporting tables. So do we judge success by the outcomes on the agenda items or not? And I guess I would say the outcomes on the agenda items are neither a necessary nor a sufficient conditions for success. There could be agreement on Article 6 and Article 13, agreement on that, and the COP could be a complete failure. First of all, because the rules might not be that great. And secondly, because even if you get a good agreement on the rules, that's not really the most important thing about whether COP26 is a success. And conversely, if you don't get agreement on those, the COP could be quite a success, I would say. So I think it's, in my view, it's a mistake to judge success by the outcomes on the official agenda, and actually sets up a lot of COPs for failures, because the official agenda and the negotiations are maybe the least progressive part of the negotiation process. So I guess I would judge success in my new think, I don't know if that's a little pejorative approach, but Climate 2.0, judge success in terms of progress on the substantive goals. And I think, as the new US climate envoy, John Kerry, has said, the goal should be to leave Glasgow with 1.5 degrees still in reach, so that you're really judging it by what progress is made on the whole ambition issue, much more than you're judging success based on the outcomes of the agenda items. Then who are the key actors to success? So of course, the old think, the traditional way of approaching it would be focus on the states and what states are doing. But I think the whole race to zero, as I'll talk about in a minute, highlights the importance of non-state actors, the business community, financial institutions, and so forth, in terms of what they can do to make COP26 a success. And then I think also in terms of this shift, a shift from thinking of success in terms of climate change specific stuff versus more whole of government, whole of society, theory of everything kind of approach. So if you think about climate finance, for example, is success in climate finance getting a ratcheted up climate mobilization goal, moving from 100 billion to 125 billion or 150 billion, or is success measured in terms of the trillions of dollars of private investment that's being made and how you shift those trillions of dollars in a more climate friendly direction? I guess I would say I would judge success much more on what's happening to those trillions of dollars rather than in terms of whether the climate mobilization goal is 100 billion, 125 billion, 150 billion, and so forth. Okay, so the other point I wanted to just make on Glasgow is, of course, Glasgow is not a singular event. There's the whole road to Glasgow. So there's going to be a whole series of meetings between now and Glasgow that are important. There's the Leaders Summit that the US is sponsoring under the new Biden administration. There are the subsidiary body meetings in beginning of June. There's the G7, which is meeting in June. Then there's the pre-COP that's held in Milan. So there's going to be a whole sequence of events that are going to be important in determining how successful COP26 is. COP26 is not going to depend just on the success, not just going to depend on what happens from November 1st to November 12th, but what happens in the interim before then. So in terms of COP26 itself, so I guess I view it maybe as a bit of a three-ring circus conceptually. So there's the intergovernmental ring. So that's going to be in the, Alok Sharma is the president of COP26. So he's in charge of the intergovernmental part. And I think that includes both the negotiations of the agenda items, but also the issues about what states are doing, parties are doing on the ambition issue. So I'd put that all in that circle. And then there's the race to zero circle. So that's the whole action by non-state actors in terms of advancing climate goals, in terms of getting to decarbonize the economy. And they're the climate champions. Gonzalo Munoz and Nigel Topping have the leads, along with Mark Carney on finance and Anne-Marie Trevelyan on resilience. And then there's this sort of traditional, and I think this is maybe something I didn't emphasize when I talked about non-state actors. Non-state actors, I think, used to be at the climate conferences more for networking, to show, to sort of for publicity purposes, trade fair, academics, NGOs, and there's still going to be that. It's the place to be on climate, to get caught up in everything that's going on. So there's that circle down here that remains. But NGOs, I think now, non-state actors are not just there to sort of be there, to be seen, but they're actually doing stuff. And the Race to Zero is actually trying to get substantive commitments by different sectors to decarbonize. So the non-state actors, I think, are not so much, I mean, they're still there to try to influence governments, the intergovernmental circle there to network and interact with other people involved. It's the best place to sort of stay in touch with what's happening in the climate world. But I think there's also this Race to Zero circle that's going to be very important. And this is a brand new to COP26, an important element of Paris, for example. What was the various commitments made by non-state actors in Paris, including the mayor's agreement. So this has been present in the COPs for a while, but I think it may be more prominent in Glasgow than ever. So the official agenda. So there's the official agenda, which I guess I would say is not the measure of success, but the official agenda includes Article 6 rules, Article 13, launching a post-2025 finance goal. There's some, I think it's going to be an agenda item on governance of the Warsaw International Mechanism. And this part is a heavy emphasis on procedure. This is what we think of as COPs as being, to some degree, dysfunctional because of this heavy emphasis on procedure. There's already procedural debates, as I understand it. I'm not involved in the negotiations these days, but what can be done in the absence of in-person meetings? What can actually happen between now and Glasgow if they're not in-person meetings? Very easy to block progress in the official agenda because there's so much emphasis on procedure. So you can object to appointing co-facilitators in the interim or having them release paper and et cetera, et cetera, et cetera. So many opportunities to block progress. And so I guess I think it's probably likely they'll be able to get agreement on Article 6 and Article 13 issues and wrap up some of the Paris Agreement Rulebook issues. Not sure because there's so much opportunity for procedural mischief by countries that don't want agreement. But yet they did get very close, I think, on these issues already. So, so potential for a resolution of those. On the Article 6 issues, there's a raft of issues, mostly political in nature. How much will the 6.2 rules, that's dealing with internationally transferred mitigation outcomes, that's like emissions trading, how much will it follow the 6.4 rules, which is the new mechanism? Will the share of the proceeds idea be required also for 6.2 transfers as well as 6.4 transfers? Will there be an expectation that the transfers will enhance overall global mitigations of emissions, or OGME in the lingo now, which is part of 6.4 but isn't necessarily applicable to 6.2? How do you avoid double counting? On 6.4, there's the double counting issue also. There's the issue as to how you transition from the clean development mechanism under Kyoto to the new mechanism established under Article 6.4 of the Paris Agreement. So there are many issues, and I don't want to belittle these issues at all because these are very important issues and they're going to be very important for the environmental integrity of the Paris Agreement. Getting agreement on these, I think, are important, and making sure that they're not just getting agreement, but making sure that the rules are sufficiently strict that they don't allow the Article 6 mechanisms to undermine the environmental integrity of the Paris Agreement. But I guess, in my view, while these are important, this should not be the measure of success for COP26. And then there's the issue of reporting. So there was agreement on much of the enhanced transparency framework under the Paris Agreement in Katowice, but there's now the remaining issue as to the common reporting tables and common tabular formats for reporting of progress in achieving NDCs and questions about how much detail to include in this, whether there should be any differentiation, and if so, how much differentiation. So there are remaining issues here as well. Okay, but I think in terms of the bigger picture, the biggest question for Glasgow is the success of Glasgow in raising ambition and putting the world on a pathway to net zero. And I guess this, of course, is super important because if you look at current policies and the pledges and targets that countries have made under the Paris Agreement to date, they put us on a pathway towards more than 2.5 degrees centigrade temperature increase and put us well above where we need to be in terms of achieving the 1.5 degree Paris Agreement goal. And this is from the most recent UNEP emission gap report showing the gap in emissions, suggesting that emissions need to be cut by roughly 50% by 2030. So extremely aggressive emission cuts necessary to put the world on a pathway to 1.5 degrees temperature increase. So this is raising ambition. And I think you can think about this in terms of what governments are going to be doing and what non-state actors can be doing. And in terms of governments, there's the short-term COVID recovery issues. There's the 2030 updated and enhanced NDCs, and then there's the mid-century net zero targets and strategies. For non-state actors, there's race to zero, race to climate resilience, and I think very importantly, the emphasis on the financial sector and private climate finance. So on green recovery, this is showing this is from Climate Action Tracker showing how different Build Back Better approaches COVID-19 recovery could have an influence on the emissions pathway. I haven't followed this closely, but my sense is maybe it's not looking so good in terms of COVID recovery as to how far down in terms of this, how green the stimulus is going to be in terms of post-COVID recovery. But the large amounts of money that are going to be spent on COVID-19 recovery will have an important influence on the emissions pathways of different countries. Then there's the NDCs. Relatively few countries have submitted new NDCs. The US, when it rejoined Paris, is now going to be submitting a new NDC, and I think they've said they're going to do that by their Leaders Summit on Earth Day in April. So what the new US NDC is going to look like, I think will set an important precedent for other countries, and hopefully these numbers, which are still quite low in terms of new NDCs, will be, there'll be a lot more between now and Glasgow. I think there's been more progress on the net zero mid-century targets and maybe some on strategies, but on targets. Of course, it's easier to promise something you're going to do in 2050 than it is to say about what you're going to do in 2030. So how much credibility these have, I think, is a question. And to the extent countries not only have targets, but put forward a strategy for how they're going to get to the target, a pathway for how they're going to get from here to there, it's going to make the targets more credible. And so I think there should be, and is to some degree, an emphasis not just on the mid-century targets, but also on putting forward strategies for getting there under Article 4.19 of the Paris Agreement. That's going to be an important metric as to how successful COP26 is. So these kind of developments on the intergovernmental side, I think some of the key meetings that are going to play a role in how successful COP26 is include the Leaders Summit that the US is putting together on April 22nd, and then the G7. I think I understand the US goal for the G7 is to get commitments from all of the major economies to have mid-century targets and strategies put forward, and that will be a focus at the G7 meeting in June. And then finally, there's the race to zero, and this is the non-state actor dimension. So the race to zero has become a major initiative, and I think a major part of the Glasgow process. So these are net zero initiatives by cities, by regions, by businesses, by investors, by universities. The climate champions play the lead role in this race to zero. Climate Action Pathways has identified 7 thematic areas, and the Race to Zero initiative just issued a few weeks ago the Race to Zero breakthroughs, which tries to identify near-term tipping points for different sectors as to tipping points to get the sectors into a pathway to zero. So I think what happens on the Race to Zero and how successful England is and the climate champions are in addressing the different priority areas they've identified, including finance, is going to be a very important factor in determining how successful Glasgow is. So with that overview, that concludes what I had to say about Glasgow. And I just want to emphasize, I think, I don't want to, maybe my comments have suggested I don't think the official agenda items are unimportant. I think it is important, but I think the whole issue of Race to Zero and ambition is really how much progress Glasgow makes is really what we should be looking for coming out of Glasgow. So thank you very much, and look forward to questions.
Thank you very much, Dan. That was a very comprehensive and very interesting talk. Really enjoyed that. And I don't think we are that far apart, by the way, on the question of how we measure success. I think the law is one layer, how we can measure success, but it's not the only one. I agree with that, actually. And it might be even worth to mention in this context that I think the UK government makes the participation in its government-managed spaces dependent on agreeing to the Race to Zero. So for cities who want to participate, they have to agree to that, not for universities, but for cities. So I think that will be an important factor in measuring the success. I actually agree with that, but it's really great to have this discussion, and you've given us so much to think about. There are already questions in the chat, so I'm not going to hijack this discussion. I will read out the questions. So the first question is, Dan, if you don't cover it in your slides, could you say more about how Paris addresses or not an experience so far, if it does, loss and damage, financial contributions and technology transfer obligations, and whether they have been met, negative emission technologies and geoengineering approaches, and intellectual property rights and technology transfer. So I think there are several questions in this one. Do you want to, should I split it up? So the first is loss and damages, financial contributions and technology transfer, and negative emissions.
So, well, thank you for those questions. So, so there's a big question as to what's happening with the $100 billion mobilization goal. So the Paris Agreement doesn't itself include the $100 billion mobilization goal, but the Paris decision that adopted the agreement does include that goal and extends it through 2025. And there's quite, I think, a dispute as to methodologically how we measure what constitutes mobilizing climate finance. The OECD has issued a series of reports that until this year had shown that it looked like developed countries were on track towards getting to 100 billion by 2020, but with COVID, that has now clearly fallen short. So I think that is going to be an issue for Glasgow, is the financial mobilization issues, trying to ramp up climate finance mobilization by countries. So I think those are all, that's an important aspect. Paris didn't really go much beyond the Framework Convention, frankly, in terms of its finance requirements. It has the same kind of quite general financial obligation that's contained in the Framework Convention itself. So I think to some degree, the enhancements on finance have come not in the agreement itself, but in this climate finance mobilization goal. But I guess, as I suggested in my talk, I think it's a mistake to focus too heavily on exactly what the agreement does on both climate finance and on climate technology transfers, because the agreement is focused on governments, and so much of what's going on is in the non-state actor sphere, and so trying to I think one of the features of Paris that's underappreciated is Article 2.1c, which states the finance goal of the Paris Agreement. And the finance goal is not limited to public transfers or even public mobilization of finance. It's to try to make all financial flows consistent with the goals of the Paris Agreement. So this includes both public financial flows and private financial flows. It includes both green finance, finance for renewables and other non-emitting technologies, but it also includes brown finance and trying to redirect brown finance into a greener direction. So it's a much, much more comprehensive approach to climate finance than the specific article on climate finance in the Paris Agreement, which is limited to public finance. So I think a focus on Article 2.1c and the potential use of Article 2.1c to try to have a much broader impact on international financial flows is important. And I think Paris Article 2.1c puts the regime on a, it flags that issue and opens up using the regime to try to achieve that goal. On negative emissions technologies, the IPCC report suggests that in order to get to 1.5 degrees, there's going to be overshoot and then coming back to levels that would allow for 1.5 degrees, and you can do that. You can do overshoot and then come back up through negative emissions. So most of the scenarios involve, or maybe all of the scenarios involve, significant use of negative emissions technologies. So the Paris Agreement, so this is not something, this is something I'm actually planning to write on, but have not yet written on, as to exactly how the Paris Agreement addresses negative emission technologies. My sense is that it does, because going all the way back to the Framework Convention, the climate regime has taken a comprehensive approach that looks not just at sources of greenhouse gases, but also greenhouse gas sinks. It's looked at net emissions rather than gross emissions. So I think there is a strong basis from the beginning of the regime for incorporating negative emissions into the framework, including negative emissions are included in the framework. So I think negative emissions do fall within the scope of Article 4. NDCs could include negative emissions. The accounting could include negative, the inventories could include negative emission technologies. So I think that fits, they do fit into the framework established generally for the climate change regime, going all the way back to the Framework Convention and including the Paris Agreement. That was all.
Sorry, yeah. Do you want to say something about the intellectual property rights and technology transfer? I leave it on mute now, so unmute.
I see.
In the Paris
so I don't think, well, I'm going to have to pass on those questions because those are not things I'm sufficiently familiar with what's going on under the Paris Agreement. I mean, I think intellectual property rights are obviously an important aspect of technology transfer, and the Paris Agreement, well, the regime going back now some time has established a variety of mechanisms, institutional frameworks to promote technology transfer. But I haven't followed closely what's happened under Paris in particular with respect to those. So can't really comment on that.
No, but thank you very much. I think everything was really well covered. So there are a couple of other questions here. Now, bearing in mind the US last-minute rejection of Charles in Article 4.4 of the Paris Agreement, to what extent do you think developing countries were made to make more compromises than developed countries at Paris?
Well, I think Paris, in my view, hit the sweet spot involving a lot of compromises on various sides. That's why I think it came into force so quickly. It was really extremely unusual that you had an agreement of this importance and this scope that came into force, in less than a year after it was adopted. That was, I think, beyond anybody's expectations. I think it raised this question as to how you would adopt the various rules, because they were supposed to be adopted by the first meeting of the parties, but the first meeting of the parties occurred much sooner than anybody anticipated. So the first meeting of the parties basically had to just meet and then go into abeyance for a few years while the negotiations on the Paris Rulebook were worked out, and then finally reconvened after the Paris Rulebook was worked out to adopted. But I think just that fact alone suggests nobody was expecting the agreement to come into force so quickly, and the fact that it did come into effect so quickly, and the fact that so many countries ratified it very soon suggests that it did command overwhelming support. So that to me suggests that yes, there were compromises that were made by, to some degree, everyone to get to an agreement that everyone could support. So, for example, in transparency, there's not the kind of differentiation that there was in the Framework Convention or in the Copenhagen Cancun approach, but there also is some differentiation through the flexibility for countries that need it. So that you find the kind of nuanced approach to differentiation, which takes a different approach on finance, where there still is bifurcation, where there's a different approach on transparency, and then there's yet another approach on NDCs, suggests that they were able to find in each of these this sort of the landing zone that everybody could sign on to, which everybody has.
Thank you very much. So the next question is, are there any signs that the UNFCCC regime may start to deviate from the state-centered approach to focus directly on carbon majors, considering that many of them are multinational companies?
Well, so I don't know if there's going to be a focus on carbon majors specifically under the regime, because the regime is still focused on states. The agreements create obligations for states. So I'm not sure that's going to happen. But I think the agreement, well, less the agreement, but the regime as a whole, if you think of the regime as a whole as including the agreement, but not limited to it, is clearly taking a much broader approach, and going back even before Paris with the Nazca portal that was established by Peruvian presidency and France, and then the decision adopting the Paris Agreement and the establishment of the climate champions, and now the race to zero. So there's a much bigger emphasis, as I mentioned, on non-state actors and what non-state actors can do. I don't know if it's going to be in terms of a sort of top-down regulation of climate majors, because I think that would require a quite significant shift in the regime that I don't think would get command support. So I think I'm skeptical that that's going to happen, but I think it's more a question of trying to use the regime to raise awareness and pressure, and also to coordinate action, and importantly to send signals to carbon majors and all climate emitters that the world is moving in a direction of decarbonization. The world is moving in that direction, and they need to get on board, and their business model needs to take that into account, or else they're going to be losers in this transformed world economy. So I think it's going to be less directly regulating carbon majors. That seems to me highly unlikely, but it's more sending them a signal as to the direction countries in the world is moving, so that they need to adapt to that changing reality.
Yeah, thank you very much. I suppose that really ties in with what you described as mega COPs, isn't it? Because these mega COPs have far more leverage in raising this awareness. Now, we've got a very long question here now. I will try to condense it a little bit. So it's from a former student who wrote his thesis at Stanford Law School. And he tried to bring a case against the US, or he was planning to write about this question against the US before the ICJ or elsewhere for its violations of the Paris Agreement until it then withdrew from it and now has luckily rejoined it. Now, during this period, he said, the Trump administration revoked the Clean Power Plan, lifted the coal leasing moratorium, etc. This has led to the US being at the critical level on climate action tracker. While I do understand that NDCs are not legally binding, can they not be taken as a threshold in the form of establishing causal links by neighboring countries of the US so that the countries can institute such a case against the US, purely basing the claim on violations of the custom international law obligations of prevention of transboundary harm, while simply referencing the provisions of the Paris Agreement? Here we are in the middle of international law. Great.
Well, so initially there'd be a jurisdictional question as to how the ICJ would have jurisdiction over the US, since the US doesn't accept the compulsory jurisdiction of the ICJ, and the Paris Agreement and other climate agreements don't provide don't provide for mandatory ICJ dispute resolution. So I think there'd be a jurisdictional issue. I think there's a political issue as to whether that's going to be a productive way to try to get action. I guess I'm skeptical of that, that even if you could get jurisdiction, and even if you could get a ruling, that would actually make a significant difference in fact. And ultimately it's a question as to what you can do to try to get countries to change their emissions, to reduce their emissions, whether that would be effective. So I think there's both a sort of legal question relating to jurisdiction, and there's a practical question as to how effective that would be. In terms of the sort of specific substantive legal question as to whether or not you could bring a claim saying that the US or other countries are not doing enough to reduce emissions and therefore are violating the duty of due diligence, that they're not exercising the diligence that's due to prevent significant transboundary pollution, and that then you could try to use, I guess, the Paris Agreement as a basis for the lack of due diligence. I think the Paris Agreement, frankly, to some degree cuts both ways, because the Paris Agreement doesn't prescribe any particular level, although it does have the normative expectation of progression and highest possible ambition. But it also has the very important principle of national determination. So to say that the Paris Agreement establishes a substantive standard of due diligence that could then be used to assess whether or not what the US or any other country was doing was satisfying that standard, to me seems like it'd be a heavy lift to try to make that argument. But I think there, perhaps another way of thinking about that is whether or not, if a country doesn't have, given the goal of well below 2 degrees and considering 1.5 degrees, if a country doesn't have any long-term strategy under Article 4, paragraph 19, even though that's not required either. But you could say, I think if a country doesn't even have a strategy for how it's going to move, what it's doing to try to achieve that goal that's been internationally agreed, that reflects a lack of due diligence. The diligence due by countries to prevent transboundary pollution should involve a planning process to what they're going to do to be on a pathway to achieving that goal. So I think there are some potential uses of the Paris Agreement in that kind of litigation to try to say that a country's not doing enough, that it's violating its customary obligations, and saying that the Paris Agreement, the goal, temperature goals, and some of the ideas in it, like planning processes and strategies, maybe do reflect some customary obligation or general principle. So I think there's some potential there. I guess I'm not a big advocate of the judicial route, and I think Christine and I kind of friendly differences on that, because I think ultimately it's going to require political change. And so the real question is whether the judicial decisions is going to contribute to political change or not. And I think that probably is going to vary a lot from country to country.
Thank you very much. And so the next question is, how do you view the Kyoto Protocol in terms of its contribution to the climate change treaty regime, and how important was it for the overall progress?
Well, having spent 2 years negotiating the Kyoto Protocol Rulebook when I was at the State Department during the Clinton administration, I guess I should have a vested interest in promoting the importance of the Kyoto Protocol. But I guess I think really looking back now over the last 20 years, 30 years, I think the Kyoto Protocol was a well-intentioned but misguided effort. It was very much based on the model that was used in the ozone regime, where they started with the Vienna Convention and then moved to the Montreal Protocol. And the ozone regime was highly successful, and the Montreal Protocol was highly successful. So I think the thinking back in 1992, 1993 was the Montreal Protocol was fresh in people's minds. It was shown to be highly successful. So the theory was, let's do the same thing on climate change as it was done on the deal with the stratospheric ozone depletion problem. But I think there wasn't sufficient appreciation of how hard the climate change problem was, how much harder it was than ozone. Not that ozone was easy, but climate change is a whole different scale of complexity and difficulty. And because climate change implicates virtually every aspect of a country's economy, it goes very much to countries' ideas about economic sovereignty. And so I think climate was much more difficult. And I think trying to have the Montreal Protocol approach of legally binding targets, quantitative targets, the world wasn't ready to accept that back in 1997, much less even today. And as a result, the Kyoto Protocol got very little participation. And the notion that originally was it would have limited participation initially, and then that would be grown out, but there was no prospect, I think. In fact, it was shrinking in terms of its participation rather than expanding. So I think actually the regime probably would have been better off if it had followed the approach of taking the Framework Convention and trying to elaborate it and make it stronger, which is essentially what Paris does. And then that initially, that would have been a more politically viable approach than what was done, because it was really something like 15 years between the beginning of the Kyoto negotiations to the adoption of the Copenhagen Accord. And the Copenhagen Accord essentially put the climate regime back on the same track it was on after the Framework Convention and moved it back onto that track from the Kyoto track. So that 15 years was a significant period of time that could have been used, I think, to elaborate the Framework Convention approach, enhance the transparency provisions, try to put more pressure on countries to come forward with pledges as to what they were going to do than there was. So I guess I think it was, even though I was quite involved in Kyoto negotiations, I do think it was, it went in the wrong direction. And now we've come back onto a track that's hopefully more productive.
Thank you. Yeah. So now the next question is, non-state actors have announced many commitments, but to maintain the credibility of non-state action in helping to deliver the 2 or 1.5 degrees Celsius target, delivering on these commitments will be key. For governments, we have an elaborate transparency framework in place. What is needed to ensure credibility of non-state action and incentivize action on the ground, and not just more commitments? Is there a role for the intergovernmental process in this regard?
Well, that's a great question. And I guess I've thought for some time now that countries should be thinking about establishing a transparency framework for non-state actor initiatives like they've done for state actions, state NDCs, party NDCs. So, I mean, the two keys, and this is sort of, I think, how Paris really represents a significant improvement over Copenhagen, is that, first of all, there's requirements when you make your pledge to provide the information necessary for making it clear what your pledge actually is. So that's the ICTU, the information necessary for clarity, transparency, and understanding. So there's upfront information, so it's clear what you've pledged. And then there are requirements about reporting on progress towards achieving your pledge, your NDC, under Article 13. So to my mind, it would be highly desirable to develop a parallel transparency regime for non-state actor initiatives, so that there are actually articulated standards for what needs to be in the pledges that are put forward. And then there's standards for what kind of information, if you made a pledge, you should be putting forward about how you're doing in terms of achieving your pledge. Right now, as I understand it, it's a little more like Copenhagen, where Copenhagen was a little like what we call the Wild West in the US, where people were just putting forward pledges and you had really no idea what the pledge even meant because they were so underspecified. And so then if you don't even know what the pledge means, you of course can't know whether countries are achieving their pledge, and then you can't criticize them for not achieving their pledge because you didn't even know what the pledge meant in the first place. And so, I think it's key for non-state actor initiatives that their pledges are clear, so that they can be held accountable for whether or not they've actually, was just an empty promise, or whether they've actually done stuff to achieve their pledge. So I think establishing through some mechanism, whether it's done through the Paris Agreement process or it's done outside it, establishing standards for that is important. I think that's been done for some of the areas. My understanding is in the cities initiative, there are significant efforts to try to establish these kind of transparency requirements so that what cities are pledging, you can actually determine whether they've satisfied their pledges, met their commitments. I'm not so sure that's happened. I think there's similar efforts in the other sectors as well, but having a general standard that's developed, I think, would be highly desirable.
Thank you very much. So I think we probably have time for one more question. I'm very conscious that we haven't gone through all of them. So I think some of these questions may need to be discussed even at the next lecture in March. But I will read out one more question at least. Now here it is. How can other multilateral environmental agreements be linked to the UNFCCC framework now before November and then thereafter?
Well, that's a great question too. So I think trying to think about climate, not just in the climate change regime, but trying to think about climate in all of the different regimes. And I wouldn't limit it to multilateral environmental regimes. It should be in the WTO, it should be in the intellectual property regime. And having all of them be thinking about climate in their work, I think, is important. So that's the sort of the whole of government, whole of society approach, rather than dealing with climate in the climate silo. So there's the idea that I think Subinius is called the Greater Paris Metropolitan Community. So there's the Paris Agreement, but there's the Greater Paris Metropolitan Community, which includes all of these other international institutions that are impinging on climate in various ways, and either in negative ways or potentially in positive ways, and trying to get them all aligned, just the way you're trying to get climate finance aligned with climate goals, trying to get other regimes aligned with climate goals, I think is going to be very important to the success of the Paris Agreement. So that's happened in some obvious cases, like the Montreal Protocol with the Kigali Amendment, which is dealing with HFCs. It's happening in the IMO with the development of their more ambitious program for targets for reducing emissions from the shipping industry. It happened in ICAO. So there's certainly some.
Oh.
Am I still there or not? I seem to have lost my video.
I think I can hear you, but I'm not sure I can't see you, I think. No.
Don't know what happened. Okay, well, in any case.
Yes, you're here, you're back here.
Okay.
That's probably a sign, isn't it? We have taken so much of your time already. So yeah, but you're back here.
Anyway, so I think that question is very much on track, and other conventions should be thinking about what they can do to try to bring what they're doing into alignment with what the Paris Agreement goals are.
Yeah, thank you very much. Are you willing to take one more question, Dan? Or
yeah, sure. I seem to have disappeared though. I'm not quite sure why.
yeah.
Okay.
Yeah, we can, but we can still hear you, and we can see,
All right, okay.
yeah, the beautiful bookshop actually.
Yeah,
So, so what do you think about a third commitment period for the Kyoto Protocol, and do you think that this will be an issue for COP26? Is the next question here.
I'm sorry, the question was about the Kyoto Protocol.
Yeah, a third commitment period.
Oh, well, I think that's highly unlikely. As I understand it, there's not a great desire for a third commitment period. So I guess I would say, not that the Kyoto Protocol is not in effect anymore, it still is in effect, it has an ongoing duration, but essentially in practice, de facto, it's been superseded now by the Paris Agreement. And so the question is how to transition some of the things from the Kyoto Protocol to the Paris Agreement, like CDM, in particular credits issued under CDM, to what degree what status they have under the Paris Agreement, whether they're recognized or not. So, but I don't see much future, as far as I know, for the Kyoto Protocol itself in the third commitment period. I think Paris Agreement is definitely where the action now is. That's the locus of attention, as it should be.
Yeah. Well, thank you very much. I think this session has really come to an end now. So I really want to thank you, Dan. It's a shame I can't see you, but I hope you can hear me. And it was wonderful to listen to your lecture. I think it's always a great luxury to sit and listen to your thoughts and to learn from that. So I think it was extremely informative, very insightful. Thank you so much. Thank you also to the audience. It was a really great discussion. We still have many questions, and I'm sorry we can't go through all of them. This is what sometimes happens with these kind of webinars, but please bear with us because there will be more lectures coming. So the next one is from David Freestone, and then we've got Christina Vogt already coming. So please come back and we will continue with this. And so this will really create a new community of people who share this interest in the road to COP26 and beyond. So I'm really looking forward to more of these lectures now in the very near future, actually. So thank you very much to all of you. Thank you.